In reviewing the documents themselves in January and February and March and April, first by hand with our team and then ultimately electronically, by the spring and early summer, we learned that there were an additional approximately 3,000 individuals, so that by late July, early August, when we issued our report to the governor, we had identified approximately 40,000 individuals whose drug samples were associated in some way with Annie Dukin.
Now, your report says there were 86,000 samples associated with her. That's far different from the initial number that we had. The initial state police database that we had said, I believe it was about 60,000 samples, so it was a huge jump. So you really had to, when you went through, you found that there were a lot more samples associated with her.
Yes.
That's what
yes.
I'm trying to get at,
I'm sorry,
more
yes,
or less,
yes.
yeah. So there, and when you say associated, you mean where she was either listed as the primary or secondary chemist?
Yes.
Now, are you confident that that number is accurate? Because we know from some of the grand jury testimony from the other chemists that they feel that their signatures were forged. So she may, and she was also in charge of the evidence room. So while she may have been listed as a primary or secondary chemist on however many samples for almost 40,000 people, it may have gone even deeper than that. What do you do about that?
My response is to go back to what I said initially. My assignment, my focus, my mission was to identify those individuals whose drug samples were tested by Annie Dukin. And that's what my work focused on. The Attorney General, as you know, investigated and is now prosecuting Annie Dukin. What that investigation revealed and what they learned as a result of their grand jury investigation or their state police investigation about what she may have done or may not have done involving other cases is something that's part of her investigation. And likewise, as you know, the Office of the Inspector General has been charged with doing a overall investigation into the practices and protocols and procedures such as the ones you mentioned in terms of evidence and quality control at the laboratory. And that investigation, as I understand it, is ongoing. What I can tell you is that I'm confident that with respect to our work, that is identifying drug samples that Ms. Dukin worked on, that based on our review of the data, based on our review of the information, based upon our hand-to-hand review of some 2 to 3 million documents, including evidence control cards and drug submission forms, and based as well as on the electronic review and collection and storage and analysis of those documents, that we have identified all of those individuals.
Mm-hmm. I want to just go back to something in the report. You had said in the report that you looked at, I believe, hand by hand, the years 2010, 11, and 12, and then electronic information became available from the Inspector General of cases that went as far back as 1998, I think. So it was sort of a review by both teams, really, of looking at all of that. Did you also hand review all of those cases as well from the Inspector General's electronic records?
We had access to certain records from the drug laboratory for the most recent 2 or 3 years, 2012, 2011, and 2010. Obviously, that was a very intensive, methodical, and time-consuming approach. We work backwards for obvious reasons from 2012 to 2011 and 2010. At the same time, both the Attorney General's office and the Inspector General's office, for their respective investigations or cases, were reviewing those same documents as well as documents going back in time. As I understand it, the Inspector General has looked at documents or will look at documents going back to the late 1990s for purposes of their investigation and their report of the laboratory as a whole. We only looked at documents and records going back to when Ms. Dukin was employed and started working at the laboratory, which was in 2003.
When you look at all of this, then what's your takeaway? Is it that 37,000 or so people were, affected by this testing, and that's the final number? You have a database that folks can look at to try to make sure that people have their day in court, and that it's a fair process, and the process up until this happened, was it in complete disarray, as some people have suggested? What's your takeaway?
Personally and professionally, the takeaway that I have had from this work is that to the extent that issues were identified, that the criminal justice system, and in particular prosecutors and defense attorneys and judges, and all those agencies within the criminal justice system responded professionally and worked together in a responsible way to enable us to identify those individuals who may have been impacted. And as you know, approximately 2,500 hearings have been held in the Superior Court alone, in which the facts and the law have been addressed by prosecutors, defense attorneys, and most importantly, judges who have made reasoned decisions based on the facts and the law. So my takeaway is that the system is working to right any alleged wrongs that may have been committed, and for those individuals whose cases may have been impacted.
But what about looking at it and saying, let's make sure this doesn't happen again? Do you look at it and say, you looked at all of these records very closely, and it took you a long time. Is there something that needs to be done to change the record keeping, to change those things, or are you not the person to make those recommendations?
Those are all very good questions, and I think perhaps they're being asked by everyone within the criminal justice system, and they're appropriate questions, but I think to be responsible, we need to wait for the results of the Inspector General's investigation and report before we can comment on what went wrong or what didn't go wrong and what changes need to be made.